Okay, wonderful. So guys, if you don't know
Hey
who
guys.
Joe is our mortgage guy with the Mahalati mortgage team with Supreme Lending. If you don't know how to reach Joe, then what are you doing? You need to go to vendors. You need to click on mortgage. Joe has his entire page there, all his contact information. For those of you that are not London Foster agents, throughout the training, I will be sharing Joe's information. Joe is a great resource for us. He's not only just our mortgage guy, but he actually helps a lot of the agents build their business, marketing, etc. So Joe, if you want to just say hello and
Yeah, great. Thanks, Memo. And I tell you, you guys always got a lot of exciting things to come, man. I'm so excited. Always keep it interesting, which is great. Yeah. So I am Joe Mahalati. I'm great to be here, but part of the London Foster team. If you guys ever need anything, we're here to basically, at the end of the day, help you build your business. Really, all our heart goes into doing that. We are really big on your brand, so we know how important that is. The company that we are a part of, we have a lot of great programs, from the standard programs that you're all familiar with, the conventional FHA, but we do renovation loan programs. We do no doc loan programs. We do a lot of these out of the box programs, but most importantly, beyond everything, is our goal is to really help build your business. And we do that by helping build rapport with those clients, whether we can help them or not. Because at the end of the day, we're not in a transition game, we're in a relationship business. And me and my team will really work really hard to do that. So I would love the opportunity to earn your business. We're here. We really specialize with helping the London Foster agents. We give all the TLC to them. And because at the end of the day, it's all about your reputation. So great to have that opportunity. I will put my contact information in the chat. And again, appreciate to be here, and thanks, guys.
okay, excellent. Thank you, Joe, again for all your time.
Yeah,
There's always somebody that doesn't have it. Guys, if you're not speaking on the call, just if you don't mind, just please mute yourself. I'm gonna try to mute everybody again. There we go. Just mute yourself because it's really crazy. You get like 35 people speaking at the same time. Man, we got a full house. Look at that, 57. I see Cervera there. I see Monique. Wow, man, we got Rosa's here. Wow, this is awesome. Guys, thank you so much for showing up. Thank you so much for sharing your screen. I know some of you haven't taken a shower, but it is definitely a lot more fun when we get to see your faces. Guys, the way that this is gonna work, and I just wanna run over it really quick, is obviously everybody who is in this call has registered for it, okay? This is a continuing education credit course, 2 hours, only what, 38 more to go? Only 12 more to go. But guys, it's really important that everyone that is registered stays on the call for the 2 hours in order for Stephen, who I'm going to introduce in a second, to give you credit for the course. I'm going to give a word at the end of this training. We are going to hold off on it. And the reason why is because we want you to make sure that you say it for the whole course. And once we give you that word, I'll give you a hint. It's a website. Once we give you that website, then you're going to have to email Mr. Stephen Guriang, who again, I will be sharing his information, and he's going to run it through the list, and he's going to say, attended, attended, attended. You have until Friday to confirm that you actually showed up with that special website. And it's going to be just an amazing way, because you start building up. Guys, it's so important to do your continuing education. If anyone has ever waited until the last minute, it is crazy. So absolutely, that's the reason why we do these trainings at London Foster, why we promote them so much and spend so much money on marketing and advertising, is because we know the value that they have, not only for realtors, but especially for our realtors. So it's something that we definitely want to do. I want to introduce Mr. Stephen Guriang. And Stephen, let me just go to your website right here. Here we go. Let me unmute you. Did you unmute yourself, Stephen?
Yep.
There you go. Okay, so this is Easy Estate Probate. It is a law firm that specializes in, guess what? Dead people. When people die, and you go into probate, which is super scary. Stephen, I'll tell you this story. This happened to me when I first came to work in Florida. You don't really care about probate. No one even thinks about it, right? And I went ahead and I took a class by mistake. I took a class at the association by mistake because I came to the wrong class. And as the story would have it, it was my first year here in Florida working, and I was with another company. And basically, I had two sellers die within the same month. I had never thought of probate. I've been doing real estate now for 26 years, never had any idea about probate, never even crossed my mind, but absolutely went nuts when this happened. And luckily, because I had taken that class, I was able to make the right contacts and reach out and try to fix it. And it wasn't it was insane, but it wasn't as insane as it was. But absolutely, Stephen, why don't you go ahead and give everybody a quick introduction to your company and what you do?
Sure. So my name is Stephen Gurian. I'm an estate planning and probate attorney, and I also have an LLM in tax. So what that means is I'm a sucker for punishment, and I decided to go an extra year in law school only to focus on tax law. So there are about 40 attorneys, more or less, in our firm. We're pretty big, and my partners handle other aspects of 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 this practice as well. So we do real estate closings, we do 1031 exchanges. Um, we deal with Ferpta, basically anything and everything having to do with real property, we essentially can handle. And I'm one of the partners of the firm. And that's pretty much it. I mean, all the boring stuff that nobody wants to do, I handle, just like the dead people and taxes. So it's pretty much it. A little Cliff Notes version about me.
Okay, wonderful. So guys, real quick, just a reminder, we're going to be taking roll at the end of this. I'm going to be sending, I'm going to be saying it. I'm going to be sending a website for everybody they have to forward on to Steve Gurian. And again, in the meantime, I'm going to be sharing on our chat his contact information. I see Joe. Is that Joe that shared his? Absolutely. Joe just shared his information. Wonderful. And Bobby, I think, shared the event information. So if you have not RSVP'd for the next training, which again is going to be live, by all means do that now. So yeah, with that said, Stephen, I want to thank you for your time. It's a great opportunity for us, and we're very excited to have you on today. And with that said, I'll just give you the floor and let's take it from there.
All right, cool. Let me share my screen.
Bobby, did I forget anything in the meantime?
Yeah, I was just about to come in and say something real quick while you're sharing your screen. I just wanted to introduce Miles again for all of you who are out there who don't know. He's kind of new to our company, but he is our marketing manager. So if you guys have any, go ahead and maybe if you can give a wave real quick so people can know who you are, Miles.
What's up, guys? How are you?
Yeah, he's our marketing manager. If you guys need anything related to marketing, he's our guy. He's really good, got tons of experience. He knows everything from A to Z when it comes to marketing. Great with viral marketing and the things that are trending, and knowing exactly how to be more engaging, not only for yourself, for branding yourself, but also for your listings and things like that. So Miles, we just want to say something real quick.
Yeah, if anybody has any questions on it as far as marketing, kind of whatever platforms you have in mind, TikTok, Instagram, Facebook, because I know videos are kind of daunting for a lot of people. Either they don't want to be in front of the camera, they don't know what to do, or they don't know the equipment. So if you have any questions, feel free to email me, text me, whenever you need. I'm available.
Yeah, we'll also put his contact information in there as well. You can reach him at media@londonfoster.com or miles@londonfoster.com. So that's it. Just wanted to plug that. And Stephen, thanks again for this training session. We're going to get a lot out of it, a lot of content. I want to pass it back on to you.
Perfect. I just want to make sure you guys can see my screen. Yeah, we're good. Awesome. So not the sexiest of topics, but kind of an important one, is probate. So what we're gonna hopefully get out of today's course is a basic understanding of estate planning and probate in the arena of real estate. So we'll talk about the probate process and how to list a property that needs to be probated. I'm gonna try to educate you guys about the probate process, including what needs to be done to actually probate, real estate, and how long it could take. We'll talk a little bit about estate planning techniques that we can use to actually avoid probate. And we'll talk a little bit about like basic tax consequences about selling real estate that's in probate and, selling real estate in general. And we'll talk a little bit about tax implications of selling real estate when we have a foreigner involved. So we'll talk a little bit about Ferpta and a little bit about how there's a difference in taxes between foreigners and U.S. citizens. So we'll deal with all of that. So let's get going. So let's begin with what an estate is. So when somebody's thinking about an estate, they're probably thinking about, something in a movie, and, if somebody passes away, you go to a lawyer's office and you read a will, and you're going to get, X, Y, and Z. But it doesn't really happen that way. Anytime somebody passes away and they own something with a title to it, so whether it's a car, whether it's a real estate, a boat, a bank account, something that an asset that evidences ownership, you actually have to go through probate. You don't just go to a lawyer's office and then, he waves a magic wand and boom, you own this asset. There is a court proceeding involved. So what exactly is an estate? So an estate is comprised of everything that you own when you pass away. So like I said, it's your home, any brokerage account that you have, retirement accounts, collectibles, personal belongings, life insurance, 401ks, all of that stuff. And it also includes property that's held as tenants in common. So that's one thing that's pretty important, is a lot of people think that because there's two people on title and one of them dies, that the other one takes it automatically. That's only true if you own property as joint tenants with right of survivorship. But if it just says, that John Smith and Jane Smith own property together, and it doesn't specify that it's with rights of survivorship, then you're going to own it as tenants in common. And if one person passes away, then you have to probate that person's share of the property. So if two people own it, you have to probate 50% of the property. If three people own it, you have to probate a third, and so on and so forth. So it's crucial that when people buy real estate and they're looking to avoid probate, like one quick little fix is putting the other person as a joint tenant with right of survivorship. So why do we need to do estate planning? So the purpose of estate planning is to control your assets while you're alive. You get to control who's receiving what, and you get to give whatever you want to that person. And you also get to appoint whoever you want to actually administer your estate or give your property to the people that you want to leave it to. You could also avoid the expense and hassle and time associated with probate. And one big thing, and we'll touch upon it today, is you could actually reduce tax liability with some proper estate planning techniques. So just some compliance stuff I have to get out of the way. We're going to go through.
Stephen, I'm sorry to interrupt you. Are you seeing the messages on the chat?
Let me see.
Somebody just asked, what if they're married? What about property held in LLC, one member or two members LLC?
Okay, yeah, I see the chat. Yeah, for whatever reason, it's popping up separately. It's not like in the actual window. Let me do this. All right. So let me scroll up to see what the questions were.
Guys, when it comes to specific questions, I think maybe we should leave this like to the end so he can go through the material, and then we'll get to like, the identifying specific questions, because now he's gonna have to stop and start every 5 minutes. But I just wanted you to be aware of it if there's anything that does fall on it. Okay.
You guys want me to answer the questions that are on the chat now, and then we'll just move on and take them at the end, or
whatever you prefer. I was just suggesting that maybe we do it at the end, because it's like they sound like they're specific cases of
yeah, looking at them. So a lot of this stuff we're gonna go through throughout
cover.
the presentation.
I imagined as much. Okay.
So
Perfect.
let's go through it. And at the end, I'll answer all the questions that you guys want. One little thing about it. So this is actually a good question that I actually want to touch upon, is property held in an LLC with one member or two member LLC. So if property is held in an LLC, it's an entity, right? It can last perpetually. So you don't necessarily have to probate the LLC, if the documents say that there's like a transfer on death. You can actually do that in Florida. So like a bank account where you can name like a beneficiary or a pay on death recipient, you can actually do that with LLCs in Florida. But if not, you actually have to probate the shares of the LLC that own the property. So yeah, let's move on from that. So like some FREC compliance stuff that's going to be littered throughout the presentation is you're going to learn a lot. But remember, you guys aren't going to be lawyers or tax professionals, so don't give the tax advice. This course is designed to help you spot issues. If you see something, you could say, okay, look, I see something, potentially difficult coming up, or I can see that there's a probate problem. Let's consult an attorney to actually deal with these issues. But definitely don't put your lawyer hat on, because then they're going to look to you if something, if something bad happens, and you definitely don't want that. All right, so let's talk about some of the basic estate planning documents that we see. We'll talk about the last will and testament, talk about the living will, and we'll talk about revocable trusts. So let's look at the first one, which is the last will and testament. So all a will is a legal document where you're going to identify individuals that are entitled to receive your property when you pass away, and you're also going to identify somebody that's going to act on your behalf if you pass away, to basically administer your estate. So what are the advantages? We get to control who receives what assets. So you're basically going to put down on a piece of paper, Johnny gets this, Janie gets that, and my wife will serve as a personal representative if I pass away. And you could designate whoever you like to be your personal representative. Doesn't have to be a family member. It could be a friend. It could be your attorney. It could be your CPA. But there is an order of preference. Let's say you die without a will. Then the state of Florida has a hierarchy of who's going to be your personal representative when you pass away. And first person is your spouse. And if you don't have a surviving spouse, then it's going to be whoever the majority of the beneficiaries elects to be the personal representative. And there's other qualifications too, like you can't be convicted of a felony. You have to be a Florida resident. You have to be over 18. But that's essentially it for who can be personal representative of your estate. Another advantage of doing something as simple as a will is you could actually minimize capital gains taxes. So step up and basis. I don't know if you guys know what basis step up is, but I'll give you an example. So let's say back in 1980, you buy a property for $100,000, just to keep the math simple. And now it's worth $500,000. You have a gain of $400,000 over the last, 20 or 40 something years. So what happens is, what a lot of people do to try to avoid probate is they do what I call the Cuban Will, which is the quick claim deed. And that's one of the biggest mistakes somebody could ever make. Why? Because you're transferring your basis in the property. So your basis is your capital, what you paid for that property the moment that you bought it. So, let's say I own this property, for the 40 years that I did, and then I pass away, but I had quit claimed it, a year before I passed away to my son. His basis in that property is now $100,000, what I paid for it. So if he goes to sell it, he's going to have $400,000 in a capital gain, which means he has to pay capital gains tax on that $400,000. So that's $80,000 that he would have to pay to the IRS, assuming he held it long term, because the long term capital gains rate is 20% at its highest. And if he decided to sell it, right away before he had held it for a year, he's going to be paying short term capital gains, which means he's going to be paying whatever his tax bracket is. So anywhere from 0% to 37% is what he'll be paying in capital gains if he held it short term. So what is this basis step up? Well, if you inherit a piece of property, whether it's through a trust, whether it's through a will, or even if you have no estate planning at all and you go through probate and you inherit something, your basis now is stepped up to the fair market value of the property on the date of death. Meaning, if the property is worth $500,000 today, my son's basis in the property is now $500,000. So what is the end game of that? Well, if he decides to sell it for $500,000, he's going to pay $0 in capital gains tax, whether it's short term or long term, because his basis is now $500,000, which is the fair market value date of death basis. So that's a huge estate planning technique that a lot of people overlook or aren't even aware of. So when you're quit claiming this property and you give that person your transfer basis, you're actually making a huge mistake from a tax perspective, especially people that have owned properties for many years, and this occurs frequently, where you have a highly appreciated piece of real estate that somebody owns when they pass away, or before they pass away, and they want to quick claim it to somebody else. Big mistake. And I know probate is somewhat expensive, but it's not going to be as expensive as paying a 20% potential capital gains tax, or even higher if you own it short term. And one interesting thing about probate is it's one of the few areas of law where attorney's fees are guaranteed by statute. So what does that mean? That means as soon as I take on a probate case and I file my petition for administration with the court to open up the probate, I am guaranteed 3% of the value of the estate as attorney's fees. So in my example of $500,000, that means I'm guaranteed $15,000 in attorney's fees simply for administering the estate. And that's only for estate administration. If there's like a will contest, or beneficiaries are fighting, or somebody had creditors, then that's something called extraordinary services under the statute. And attorneys could actually charge on top of that 3% this extraordinary service. So they could actually charge hourly for doing work outside of your typical probate administration. So this $500,000 estate in my example could potentially be more than $15,000 of fees, if there's some, side issues that are going on. So back to the advantages. I mean, a will is cost effective. I mean, most attorneys will charge anywhere from like $500 to $1,000 to do a will. But one of the biggest misconceptions, and this is a huge disadvantage, is that you do have to go through probate. So there's a big misconception out there that because you have a will, you avoid probate. And that just simply isn't the case. So what happens is you have a will, and it's great because you're telling, basically putting the world on notice who's getting what and who your PR is going to be. But you still have to go to court, and you still have to go through a judge to actually distribute those assets. So you actually need a court order distributing what you have to your beneficiaries. So, and probate can take a while. I mean, if it's a vanilla probate, you're probably looking at 6 to 9 months on the shortest end. If you have people fighting your creditors, or you're having a tough time selling property, it could potentially take a year or more. Typically, from my experience, I usually get them done between the 6 and 9 month mark. I tend to move my cases fast, but not all attorneys are the same. Depending on an attorney's workload or the amount of cases that the courts have, it could take a while to get things done. Another disadvantage is, wills need to be revised every couple of years. So anytime there's a life-changing circumstance, a divorce, a new child, or you get a new asset, you're going to want to revise your will. And the other thing, and I kind of touched upon it, is that it's expensive to go through probate. That 3% isn't cheap. What if you have $1 million estate? That's $30,000 in attorney's fees that are going to be racked up just for administering the estate. And most people have creditors. I mean, most people have credit card debt, and they typically file claims against an estate. And usually you'll get a credit card if you had like a hospital bill or something like that. Typically they'll file claims against the estate as well. If you had Medicare or Medicaid, the state of Florida will file claims against the estate, and they usually do. I would say like 90% of the time, if you had Medicare or Medicaid, they're gonna file claims against the estate for all of your benefits that you use within the last 60 days of your life. So let's talk a little bit about a living will. So a lot of people confuse a living will with the last will and testament. They're actually two different documents. So a living will is just a written statement that details a person's preference regarding medical or surgical treatment when they're incapacitated and they can't actually speak or give informed consent. So quickly, why is this necessary? You get to decide what type of treatment you want or don't want if you're, in a coma, let's say. If you don't want to be on tubes or you don't want to be in an iron lung, you basically let your family members and your treating physicians know, that you don't want that treatment, or maybe you do want a specific medical treatment, and you do that in a living will. Another advantage of having this is you get to avoid fighting amongst your family regarding what type of medical or surgical treatment that you want. I don't know if anybody remembers the whole Terry Schiavo situation from about 20 years ago. where Jeb Bush had to get involved when he was governor, and they were trying to figure out whether or not to, take Terry Schiavo off life support. That became like a really big deal, in the early 2000s. So you essentially avoid that whole situation with something as simple as a living will. And the main thing is you're going to ensure that your family and your medical professionals are going to, respect, what your last wishes are regarding your medical and surgical treatment. So, again, having something as simple as this will go a long way in avoiding any kind of fighting. Now let's talk about the revocable trust. So it's similar to a will in that it's a document that creates a mechanism where you're going to be able to transfer assets to your beneficiaries, and you appoint a trustee as opposed to a personal representative to actually manage your assets. But the big thing here is that you actually get to avoid probate. So this is the way you could avoid all that time, all that headache, all those attorney's fees, is by setting up a trust and sticking your assets or your real estate inside of a revocable trust. And one of the benefits is that if it's revocable, you could actually amend it at any time that you want. But one disadvantage is that if you pass away, you actually can no longer amend the trust. So it becomes irrevocable at death. So whatever you put in there while you were alive, that's going to be the law of the land, and that's what's going to control. So, your kids or your spouse or, whoever your beneficiaries are, they can't change anything after you pass away. But like a will, some advantages are that you control who receives, what assets. You could designate whoever you want to serve as trustee. Like I said, you could amend it and you could even revoke it. So let's say from one day to the next, you decide, you know what, I don't want to do this trust anymore. You essentially, rip up the sheet of paper and that's it. You no longer have a trust. And another cool thing is that you minimize capital gains taxes, just like what we discussed with the will, the step up in basis. You actually get step up in basis if you stick assets in a trust as well. So that example that I gave of the property that I bought for 100,000, that's now worth 500. You get that step up in basis if you stick it in a revocable trust. One of the disadvantages also is that it's more costly than a will to create. I would say attorneys probably charge anywhere between $2,500 and $7,500 to draft trust. It just depends on the complexity of the trust and what type of trust. There's all sorts of trusts that you can have. You can have irrevocable trusts that hold life insurance. They're called ILITs. You could have offshore trusts. Sometimes you could have revocable trusts that aren't that simple. Maybe you've got like 3 or 4 kids, and maybe one of them is like doing drugs or something. You could actually put in the trust that they don't receive anything if they're on drugs or if they're incarcerated. You essentially could stipulate whatever you want in the trust. So if you're going to put like restrictions on kids receiving something, like they'll receive the house when they get married, or they'll receive a chunk of cash if they graduate from college. You could basically do whatever you want with a trust. And that's one of the cool things about revocable trusts. The other thing that you have to be aware of as well is that if you transfer real estate to a trust, you're going to need bank consent to transfer the mortgage property into a trust, because it could potentially trigger a due on sale clause. Now, not all mortgages have this restriction. Some mortgages allow you to do estate planning where you could actually transfer your real estate to this revocable trust. And if they do that, then you're great. If you get their consent, no problem. But if there is a due on sale clause and you transfer the property into the trust, if the bank finds out, they can foreclose. Although from experience, that's pretty rare. Typically, if you're paying your taxes, your insurance, and your mortgage, you should be okay. But it's something to be aware of, is that you can trigger the due on sale clause on the mortgage if it has one, and you transfer, basically change title. So now that we've talked a little bit about the actual estate planning documents, let's talk a little bit about probate and some listing issues that I see, quite frequently when we're selling property that's in probate. So who is it that's actually selling the real estate when a seller is deceased? It's actually the estate. So a lot of times what I see is, kids of somebody that passed away, they're signing the listing agreement, they're signing the FAR contract, and they actually can't do that because they don't own the property. You have to go through probate first and get them untitled to the property to be able to sell it. But I see this all the time. The kids sign listing agreements or the FAR bars, and then you get stuck at the closing table, and you lose all that time. So to get ahead of it, what we should do is put the estate of the deceased person on the listing agreement, or what you could do as well, and this is actually the better practice, is you put the name of the person that's serving as personal representative. So as you see here on the slide, it'll be Jane Doe as personal representative of the estate of John Doe, because it's the actual personal representative that manages the estate when somebody passes away. So they're the ones that have the authority to sign the listing agreement, to sign the as is. They're really the ones that are driving, this bus in probate. They're the ones that are signing all the documents that go to court. They're the ones that are settling claims with creditors, that are actually distributing the assets to all the heirs or beneficiaries. They're the ones that are in charge of doing everything that's supposed to be done inside of probate. So again, who signs a listing agreement? It's going to be the personal representative. And then who signs the sale and purchase agreement for the deceased real property? It's going to be the personal representative. Now, who has to approve the sale and purchase contract? It's going to be a combination of the beneficiaries, the personal representative, and your judge. So typically what happens is, if we have a property that's in probate, the personal rep is going to sign the contract, and they have to put in the contract that it's subject to court approval. Why is that? Because neither the beneficiaries or the personal representative actually own the property. It's somebody that's deceased that owns the property. So you have to present this contract to the court. The judge is going to take a look at the contract, make sure that it's being sold, for fair market value, that the estate isn't, getting ripped off, so to speak. And if the court approves the contract, you're good to go. And you could sell the property without any issues. So let's talk a little bit about this court approval process. So typically what you're going to need, at least in Dade County, you're going to need 3 comps or a full-blown appraisal. And I'll tell you that right now, if you're selling property that's worth more than $600,000, you're going to need an appraisal. Otherwise, you're okay with the 3 comps. You're also going to need a broker's opinion of value that basically states that the property is being sold at fair market value. And you're also going to need consents from the beneficiaries. So this last part is kind of like what gets a little tricky. Depending on the judge, if you have at least a majority of the beneficiaries in agreement to sell the property, the judge will likely sign the order authorizing the sale. Some judges want unanimous consent from the beneficiaries. It really all depends on the judge. And the reason is because, the beneficiaries are entitled to the property. If they don't want to sell, they don't necessarily have to, at least in the probate case. The other thing you could do is you distribute the property to the beneficiaries, and you could actually institute a separate action called a partition, and then that's where you could force the sale, and you get a court-appointed realtor to list the property and show it. Usually doesn't go that far. Most of the time, from experience, if a majority of the beneficiaries consent to the sale, it's going to happen. And there's other factors that go into that too, right? Let's say property taxes haven't been paid, or there's a mortgage on the property and you're behind. I mean, if there's a beneficiary that doesn't want to sell, it's all well and good, but are you going to pay for the taxes? Are you going to pay for the mortgage? Are you going to pay for the upkeep of the property? If the answer is no, then you got to sell. Otherwise, all you're doing is, bleeding the estate dry, and, you're going to have to pay, penalties and interest from the mortgage company. If they accelerate, you're going to have to pay attorney's fees. So it just doesn't make sense to have a carrying cost that exceeds its value. So if there's a situation like that, where the house is essentially bleeding money, judges are pretty, sympathetic, and they'll approve the sale, even if you don't have consent from all the beneficiaries. But you definitely would need at least the majority of the beneficiaries to sign off on selling the house. Otherwise, you're just going to have to go to a hearing, and everybody kind of says their piece in front of the judge, and it's up to him as to whether or not the property gets sold. Another thing I want to talk about is creditors. So Florida law requires that the personal representative publish in what we use down here is the Daily Business Review, a notice to creditors. In other parts of the state, so basically, I think north of Palm Beach, you have to use a different publication, but basically South Florida and the Keys, you can use the Daily Business Review to actually publish this notice to creditors. And it just basically says that, John Smith passed away, and if John Smith had any creditors that any creditors that have claims, they have a period of 3 months to file a claim against the estate. Otherwise, if they don't file in that 3-month period, their claim is barred. So what does that mean for us or for you guys as agents? So estate property can't be sold or distributed until the expiration of this creditors period. And the creditors period lasts 3 months. And it's 3 months from first publication. So let's say publication first occurs on January 1st. The creditors period will end April 1st. It's a 3-month period, not a 90-day period. And that's a pretty important distinction when it comes to timing. And creditors' claims need to be resolved prior to selling real estate. Otherwise, you're going to need that court order to sell the property. And depending on the county that you're in, you might need a court order anyways. For instance, Dade County requires a court order to sell real estate no matter what. Broward, it depends. It depends on whether or not there's creditors' claims or if a decedent's been deceased 2 or more years. They're a little bit more lenient in Broward than they are in Dade County. And Palm Beach is pretty restrictive too. And right now, Palm Beach is very backed up with cases, and they're actually taking a while to issue orders and things like that. So not a good time to go through probate in Palm Beach County at the moment. So one way around being able to sell property during the creditors period is something called setting up a court-restricted account, a court-restricted depository. So in most cases, probate cases, where there's either liquid assets or property that's going to be sold, and we know there's going to be cash and there's going to be something fungible, the judges are going to require us to open up what's called the court-restricted depository. And what we do is we transfer any cash assets that a decedent had to this court-restricted account, and it stays there until the creditor's period expires. And the reason it stays there is if there's a valid claim from a creditor during that 3-month period, and they present the claim and it turns out to be legitimate, you have to pay those creditors from that money that you have in that court-restricted account. And creditors actually get paid before the beneficiaries do. So long as the estate has equity, creditors' claims are going to get paid first, and then the beneficiaries get paid. And there's actually a hierarchy of claims that can be paid before beneficiaries get paid. Number one is us attorneys. We actually get paid before anybody. We even get paid before the IRS. You have funeral expenses. You have hospital bills. There are 8 classes of creditors. I don't remember them all at the moment at the top of my head. Medicare is one. But basically, you go down the list until you get to what's called the Class A creditor. And they're the ones that get paid last. So that's like your credit card debt, your unsecured creditor. So IRS is getting paid first, expenses of administration. So let's say you're paying for the funeral. You actually get to be reimbursed that off the top. So once they file a claim, it's up to the PR to either object to it or pay it. If the personal representative objects to it, then the creditor has 30 days to file what's called an independent action against the estate, where they basically sue the estate for their claim. And if they don't do it within those 30 days, then their claim is barred, and that's it. They can't do anything. So if there's a claim where there hasn't been an independent action filed and you're trying to sell real estate, you can, because if they didn't exercise that right within the 30 days, you could sell. So that brings me to another point, which is homestead property. So Florida is one of the few states in the country that has this homestead benefit. And most people, when they pass away, they usually own, one property. I mean, sometimes they have their homestead and like an investment property or a secondary home. But what Florida allows you to do is, even if you have creditors, and it depends on the creditor, but if you have creditors, if you get the property designated homestead by the court, then you actually don't have to worry about getting a creditor's consent or dealing with the creditor's period when you're selling homestead property. So, how do you get property declared homestead? What you need to do is get a property appraiser's printout showing that the property was the decedent's homestead, and I'll go through that at the end of the class. You're going to have to get a tax bill showing the decedent paid all the real property taxes until they passed away. And in Dade County, you're going to need an affidavit signed by a disinterested third party stating that the property was the decedent's homestead. So if you get those three things and your attorney files a petition to determine homestead with the court, the judge is going to say, okay, this was homestead property, so creditors can't go after it. So if, John Smith racked up a huge bill with American Express, let's say he owed like 10 grand to American Express when he passed away, if his property is determined to be homestead, they can't do anything about it. So you actually don't have to pay that American Express claim if they file the claim or the bill if you're selling the homestead property. If there's property that isn't homestead, then yeah, it's fair game for creditors. But homestead is one of those benefits of being a Florida resident, that no creditor can go after your homestead property. But there's three exceptions. So the first one is your first mortgage, and it makes sense. If you mortgage your property, they can foreclose and take your property away from you. Number two is property taxes. So if you don't pay your property taxes, the county can sell your property at a tax deed sale, and that also makes sense. And then number three, which a lot of people don't know about, are mechanics liens. So let's say before somebody passed away, they hired somebody to put in a new roof on their house. Typically what they do is a notice of commencement, and they record it, letting the world know that this contractor is about to do work to this piece of real estate. And then if they don't get paid, they file a claim of lien against the real estate. So if that contractor files that claim of lien and it's a mechanics lien or home improvement lien, then that is also not going to be exempted from homestead. So you're going to have to pay that. So if you don't have one of those three, then you're good. Creditors can't go after homestead property. If you do, you're going to have to pay them. And declaring property homestead is a huge advantage here in Florida, because let's say, here's another example too. Let's say the person that passed away had a judgment against them. If you get the property declared homestead, it eliminates the need to negotiate with that judgment creditor because it's homestead property. So a creditor's interest in an estate is wiped out if an order determining homestead is entered. But again, that only applies to creditors that are not your first mortgage, property taxes, and mechanics liens. If for whatever reason you file, or the attorney files a petition to determine homestead and the creditor objects, then there's going to be a hearing, and the creditor has to show why the property wasn't, homesteaded. So it's their burden to show that it wasn't homestead property. Usually doesn't happen. I've never seen it happen. If you get these three things that I was talking about, the property appraiser's printout, the tax bill, and the affidavit, it's pretty hard to rebut the presumption that the property was homestead. And the other thing too is, if creditors don't object, then you could actually sell the property without their consent. So even if you have a creditor file a claim, doesn't matter. If they don't object to the designation of property as homestead, you could sell it, no questions asked. So definitely speak with your personal representative or your beneficiaries, whoever it is that you're going to represent with the listing, about the existence of creditors. So knowing about them ahead of time will make selling homestead property much easier, much quicker, and you just don't really have to deal with these creditors. And the other thing too is that you have to make sure that the attorney that you're working with is going to get that notice to creditors published early on to start the clock on creditor claims. A lot of times attorneys will wait to the last minute to publish the notice. but maybe you already have the listing agreement signed, or maybe even worse, you're under contract, then you got to wait these 3 months, and it's going to push, closing back until you resolve all these issues with the creditor claims. So as soon as you get a personal representative appointed, make sure they're on top of their attorney to publish that notice to creditors and start that whole creditor period, right away. So again, remember, as real estate licensees, you can engage in the unlicensed practice of law. The course is designed to spot common issues when listing or selling property that has to go through probate. While you have a basic understanding of what's required to list real estate that's going through probate, don't give legal advice. Have the attorney and the CPAs give all that advice. If something goes wrong, you definitely don't want to be the scapegoat. So spot issues. If you see something that's kind of funky, or you say, oh, you know what, I think you have to go through probate here, contact an attorney. So let's talk a little bit about some of these tax implications as well. So we talked a little bit about step up in basis, but I actually want to talk a little bit about estate tax. So right now, under current law, if you own less than $12,060,000 of assets, you're never ever going to have to worry about having to pay estate tax. However, if you own more than that, you're going to have to pay estate tax. And estate tax is 40% on every dollar in excess of that $12,060,000 mark. And it seems like a lot, but not too long ago, it was like $1 million. And last year, there was some legislation to reduce that exemption amount. Last year was 11.7, but let's just call it, 12 million, just to keep the math simple. There was some proposed legislation going around to reduce that $12 million mark to $3.5 million. So that's huge. That means that anybody that owns a house in Coral Gables will have to pay Uncle Sam estate tax if they pass away. And they're kind of at it again. I'm sure you guys have probably heard in the news recently, there was this huge healthcare bill that passed. So now that that's done, and there's some closure on that aspect of things, Congress is going to start ramping up to go after the estate tax exemption, and they're going to try to reduce it. Typically, they have until the end of the year to come up with legislation for it to be enacted for the following year. So unless they do something before December 31st, we're probably still going to have the $12 million exemption amount next year. Another thing they tried to do was remove the step up in basis, which is huge. The step up in basis has been around for years. So that would be a huge blow, for taxpayers if Congress did that. But right now, that's not so much under attack as reducing the $12 million to $3.5. In 2010, the amount was actually $5 million, and it's been adjusted for inflation ever since. And then in 2018, with the Tax Cuts and Jobs Act, whatever it was that Trump did a couple of years ago, he doubled the exemption to $10 million, and it's been adjusted for inflation ever since. So and that law is actually set to expire in 2025. So if Congress doesn't do anything between now and then, it's going to go back down to $5 million adjusted for inflation. So that's just something to kind of be aware of. And let's talk a little bit about gift tax. Not too many people know this, but you could actually gift anything of value that's $16,000 or less to somebody tax-free. But to the extent that you make a gift of over $16,000, you're actually supposed to report it to the IRS, and there's gift tax on it, and it's also 40%. And we talked about step up in basis already. So like I said, don't do a quick claim deed. If people that want to do estate planning through quick claim deeds, don't do it. Something as simple as a will is going to save thousands of dollars in taxes. And you could eliminate gift tax if you do something through a will as opposed to a quick claim deed. So people that are actually quick claiming all these properties, chances are the property's worth more than $16K, and you actually have to pay gift tax on that, or at least report it to the IRS. So that's something to have in the back of your mind. Um, so like I said, some common mistakes are transferring capital assets during one's lifetime, and that eliminates the step up in basis and gives a transfer basis. And while you avoid probate, you could expose yourself to taxes that are going to exceed the cost of administration for probate. And we talked a little bit already about, if you do a quick claim deed, you could trigger the due on sale clause and unintentionally trigger a bank foreclosure on the property. But again, that's pretty rare. Like I said, there's some mortgages that I've seen that actually allow you to do estate planning and transfer property if it's to your own trust, where you're the trustee and initial beneficiary of the property. So now we talked about us, let's talk a little bit about non-residents. So like I said, if a U.S. citizen passes away and they own $12 million of assets or less, never ever have to worry about Uncle Sam. But guess how much it is for non-U.S. citizens? It's $60,000, and we're getting an influx of foreign money, at least in Miami, buying real estate. And chances are, those condos in Brickell are worth more than $60,000. So to the extent that a non-resident alien owns assets in the U.S. and it exceeds $60,000 of value, they're going to get taxed at a rate of 40% for every dollar above 60,000. So that's huge. So the IRS does not treat U.S. citizens and non-residents, the same, and they're taxed on, and just like us, any property that's situated in the United States that's owned by citizens or non-resident aliens is subject to estate tax to the extent that it exceeds those levels. So $60,000 for them, 12 million for us, and the rate is the same, 40%. And again, it's 40% of anything above 60,000 for NRAs or 12 million for us. So how do we avoid this for us? Gotta make sure that $12 million mark stays at 12 million for the next couple of years. Or you do some estate planning and try to take advantage of some like the loopholes and things like that. But it's a little bit harder for us to avoid estate tax as opposed to non-residents. So non-resident aliens could actually eliminate the estate tax if they own real estate through an offshore holding company. So what was really popular back in the day was, BVIs. A lot of South Americans used to purchase real estate using BVIs a while ago. You were anonymous. There was no registry of directors of the company. And that was very important for Colombians, and it's probably going to be important for Colombians again now, given what's going on. But I want to say like 8 or 10 years ago, BVI started, sharing the identity of the directors of the company, so there's no longer that anonymity. So what a lot of attorneys are using now is a Nevis corporation or a Nevis partnership, and that's another island in the Caribbean, but it functions the same. So what you do is you have this non-resident own real estate through this offshore holding company, and then you actually avoid estate tax. And why is that? Because estate tax only applies to individuals. So when an individual passes away, if their net worth at the time of their death exceeds, the two levels, 60,000 or 12 million, you got to pay the estate tax. However, if you own an interest in a company that owns the real estate and you're a non-resident, if you die, you own an interest in a company that's offshore. So it's not a company that's a U.S. company. And because Nevis has no estate tax, doesn't matter how much the value of the property is that Nevis company owns, you're not going to pay estate tax. And again, you don't own any U.S. real estate or any U.S. asset. So without owning any U.S. asset, you're not going to pay U.S. estate tax. So again, by owning real estate through an offshore entity, you're going to eliminate the estate tax. And again, companies can live perpetually. So, an estate tax would never apply to a corporation. It only applies to individuals. Gift tax as well only applies to individuals, not entities. But there is a problem if a foreigner owns U.S. real estate through a holding company that's offshore, and that's Ferpta. So Fripta is a 15% withholding of the gross sales price of the property that's being sold by a foreign person or a foreign entity. So in the structure that I just discussed of having the offshore, if you have an offshore company owning U.S. real estate and it sells the real estate, you have to withhold 15%. But there is a way around that as well. If you own a property here in the U.S. and you're a foreigner, if that property is owned directly by an LLC or a C corp, and that C corp is owned by the offshore, you're going to eliminate FERPTA and estate tax. Why is that? So we already discussed the whole estate tax issue because the individual owns a foreign entity, so it's not subject to U.S. estate tax. But how is it that we avoid FERPTA? Well, if you have a U.S. corp owning U.S. real estate, it doesn't matter that it's owned by a foreigner. It's a U.S. corporation, so you don't have to worry about that 15% withholding. So you have your FERPTA insulator with that LLC or C corp that owns the real estate, and then you have your estate tax insulator with the Nevis or BVI or whatever foreign entity you want to use to hold that C corp or LLC. So how is it that non-residents are taxed? So just like us, non-residents are taxed based off of what they own in the U.S. But unlike us, they are only taxed for estate tax purposes for their assets that are situated in the U.S. Us as U.S. citizens, we're taxed on everything that's worldwide. So if you have a vacation home in Tuscany or something, you have a villa in Tuscany, and you pass away, IRS is going to include that as part of your estate for estate tax purposes. But if you're a foreigner, U.S. only cares about U.S. assets. And like I said before, the estate tax rates for U.S. persons and non-resident aliens are identical, and it's 40% above those thresholds. And interestingly, like I said, estate tax exemption for us has increased throughout the years. Again, not too long ago, it was like at $1 million, I think like in 2000 or 2001, something like that. But for non-residents, it's never increased. And it's been, $60,000 as far as I know, basically from like the beginning of time, essentially for them. And that's probably not going to change. They're only going to have that $60,000 exemption as opposed to us, 12 million. But again, depending on what happens with any new legislation, it might go down to 3.5, might go down to 5 when the law expires. Nobody knows just yet. But there is that legislation that's pending. So we kind of talked about this too. U.S. situs assets. So those are the assets that are in the U.S. or situated in the U.S. Real estate is subject to estate tax. Tangible personal property that's located in the U.S. is subject to estate tax. And again, this is for foreigners. Stock in U.S. corporations is subject to estate tax. Interestingly, cash isn't. So technically, and I said this, anything that's located in the U.S. is subject to estate tax, but if it's cash that's in a bank account and it's, just static, it's just sitting there, it's regular deposit, it's actually not subject to estate tax. So a foreigner could have $1 million parked in a savings account or checking account in Bank of America, and they're going to pay $0 in tax. However, if that money was generated from a trade or business here in the United States, then they actually have to pay the estate tax. So if it's what's called effectively connected income from a U.S. trade or business in the U.S., it's fair game for estate tax purposes. This is actually a good stopping point for questions because I see the chat was blowing up like crazy. Let me see if there's anything I could answer relatively quickly. Okay, good. So somebody had asked about applying for an EIN. So, and we're actually going to get to that in Ferpta. So foreigners that are looking to invest here in the U.S., if they are opening up a LLC or a C corp, you're going to need to get an EIN to open a bank accounts, right? So how do you do that when you're a non-resident alien? They actually have to get what's called an ITIN for themselves in order to, which is basically like a social security number, in order to conduct business here in the U.S. Or if they have a U.S. partner or a U.S. citizen that has a social security number, that person could apply for EINs if they're opening up LLCs or S corp. Or C corps here in the U.S. Foreigners can actually not own S corps. Foreigners can only do LLCs or C corps. So let's talk a little bit about Ferpta. Fripta is the Foreign Investment in Real Property Tax Act. We're going to talk a little bit about the general rule. We'll talk about exceptions to the general rule, and we're going to talk about liability of the parties to the transaction where there is Fripta withholding. So the general rule is unless otherwise provided in section 1445, any disposition of United States real property by a foreign person shall be the transferee shall be required to deduct and withhold a tax equal to 15% of the amount realized on the disposition. So that is the rule. So what does that mean? There's a lot of technical terms there. So disposition just means the sale of the property. A U.S. real property interest means real property that's located not only in the continental United States, but also the U.S. Virgin Islands. So if you have a foreigner that's selling a property in the U.S. Virgin Islands, it's subject to Ferpta. And a foreign person is a non-resident alien for income tax purposes. And we're going to get into non-resident versus resident aliens in a moment, because there are some ways around that foreign person classification. And then the transferee is the purchaser of the real property. And then your amount realized is the contract sales price. So a lot of people think that the Ferpta is a withholding on the net amount. So whatever you sell the property for, less closing costs, commissions, all of that. But it really isn't the case. It's whatever the contract sales price is, exclusive of closing costs. So whatever's on the FAR bar, that's the amount that you need for purposes of calculating your withholding for Ferpta. So let's talk a little bit about exceptions to Ferpta. So the most common one is that the seller furnishes what's called the Non-Foreign Affidavit. And I'm sure you guys have seen this one. It's super common. It's just basically a one-pager that says you're either a U.S. citizen or U.S. Permanent resident. You have either an ITIN number or a social security number, and you're just stating under oath that you're not a foreigner and that you're going to reside at that property as your residence, and you're going to provide a U.S. address in the non-foreign affidavit. Another pretty common exception is a qualifying statement. That's just basically an agreement that you've reached with the IRS that either eliminates or reduces withholding. And we'll get into a little bit more detail about that in a second. Another one that used to be super common, but I don't think so anymore, is the personal residence exemption. So if you're selling real estate where the amount realized or the contract sales price doesn't exceed $300,000 and the buyer is going to use it as their primary residence, you don't have to worry about withholding for a Ferpta, even if you have a foreign seller. But I don't know what's going for $300,000 and under in South Florida these days. So let's talk a little bit more about the non-foreign affidavit. So like I said, it's the most commonly used exception to Ferpta withholding. The non-foreign affidavit is supplied by the seller and it's given to the purchaser and the closing agent. All you're saying is that the seller is not a foreign person or not a non-resident alien. You're going to supply an ITIN number or a social security number, and you're going to supply the seller's home address. which has to be a U.S. address. So what does the non-foreign affidavit look like? It's basically this. Again, you're just saying that that the seller is not a foreign person, that they're a U.S. Citizen or permanent resident, and that withholding is not required because you're supplying Social Security number, your ITIN, and you're stating under oath that you're not a non-resident alien for income tax purposes. And like I said, you do this under oath. If somebody ever lies about this and the closing agent finds out, they need to immediately notify the IRS that somebody basically perjured themselves on a non-foreign affidavit, because the IRS is really, really strict about people dodging Ferpta. What had happened years ago, the whole reason it was even enacted was that what happened years ago is that people would buy real estate in the U.S., sit on it for a while, it would appreciate in value, sell it, and then leave the country and never pay any taxes. And they knew they were never going to come back to the U.S., so they didn't care if the IRS was going to go after them, because, I mean, the IRS can't police the world. So they had enacted Fripta to retain 15% of the gross sales price. And a lot of times, and going to our next example, a lot of times that 15% exceeds the actual tax. So what do we do in that situation? You get a qualifying statement from the IRS. So like I said earlier, the IRS basically reaches an agreement with the taxpayer about what to pay in terms of Fripta withholding. Or maybe the transaction is exempt from Fripta. Or maybe Fripta has been satisfied, or the seller posted a bond to cover the tax liability to the IRS. Problem here is that while the instructions say that the IRS has 90 days to process a request for a qualifying statement, they take a lot longer, especially ever since COVID. A lot of these requests are taking 6 months or more, and in some instances, I mean, you may have done the request timely, but these foreigners aren't getting their refunds for about 2 years, so it is taking a while. And typically, you're going to want to do a qualifying statement when you know that your tax is not going to exceed the withholding. So what does that mean? Maybe you have a foreigner that's selling property at a loss, right? So if they were to do their taxes, they're going to declare a loss on the property. So they're not going to be paying any tax yet. However, under Ferpta, if you're a foreigner and you're selling real estate, you got to withhold 15% of the sales price. So in a situation like that, it doesn't make sense for a foreigner to remit the 15% when they know that they'll be getting a refund of that 15% when they file taxes the following year. So instead of giving the money to the IRS and then waiting years to get your refund, what you could do is fill out an 8288B or ask for a reduced withholding certificate. And your closing agent's actually going to hold on to the money. They're actually not going to remit it to the IRS, but they're going to hold on to the money until the IRS sends a notice saying, you know what, okay, Ferpta doesn't apply in this situation, or the withholding exceeds the tax, so you're going to pay a lesser amount, or you don't have to pay anything at all. And then once the closing agent gets that statement back, they could actually release the money directly to the seller, and that's it. You never have to worry about it again. But like I said, lately these requests have been taking a long time, but you're probably better having the money being held by your closing agent than you would if you're giving it to the IRS. And actually part of that tax bill the healthcare bill that passed recently is the IRS has been injected with some more money to try to move these files along, and not just Fripta, but just in general. So you're probably going to see a lot of audits going up next year, now that the IRS has been funded with some more cash. So we'll probably see a lot of Fripta audits as well. So let's talk a little bit about the personal residence exemption of Fripta. Like I said earlier, the purchase price can't exceed $300,000. And the real property has to be the primary residence for the purchaser. And the buyer has to be an individual. So entities don't qualify. So no LLCs, no S Corps, no C Corps, no partnerships. It has to be an individual purchaser for this exemption to apply. There's a little nuance though. So what happens is a lot of foreigners buy real estate maybe just in their name and not in their spouse's name, or they do buy it as husband and wife, but they have kids and they're looking to reside at the property. But children can't own anything unless they're 18 years of age. So there is a little nuance here. So as long as the buyer or members of their family reside at the property for 2 years immediately after the sale, you can qualify for the personal residence exemption, even if the buyer that's on title isn't necessarily residing there all the time. So the IRS provides that an individual purchaser satisfies this residency test if the buyer or members of their family actually reside at the property at least 50% of the time that it's used by that person during the 2-year period following the purchase. So if you're there at least half the time following the 2-year period after you buy, you're gonna meet that qualifying personal residence exemption, and Ferpta wouldn't apply. And similar to the non-foreign affidavit, there is another affidavit that's signed by the buyer in this instance for the qualifying personal residence, and it's basically going to state that I'm planning on using this as my primary home, and I'm going to be here at least 50% of the time during the 2 years after I sell. And you don't even really give that to the IRS. The closing agent holds on to that. So again, as a legal disclaimer, some FREC stuff. Don't engage in the practice of law. While you have a basic understanding of what is required to list estate-owned real estate, as well as now you have some knowledge about tax considerations, don't give legal advice. Always consult with a tax attorney or a probate attorney regarding these estate planning issues or tax issues. An experienced attorney will be in a position to guide you through this complicated probate process. And now what I want to show you guys is the homestead stuff that I had talked about regarding probate. So, whoops. So like I said, if you're selling homestead property and it's going through probate, you need to get the property appraiser's printout. You're going to need to get a tax bill showing that the decedent paid all the property taxes, and you need an affidavit signed by a disinterested third party. So I want to show you guys how to locate this stuff. So let me bring up my browser. And I live in Miami. I don't know if you guys are all Miami based or Broward or what, but this is just easier for me. So I'll use me for instance. So if you look down here, you're going to see where it says Homestead. And that's going to tell the judge that the property is being used as a primary residence or as a homestead property for property tax purposes and homestead purposes for probate, so constitutional homestead. So you're going to want to get this printout up here. You can either do detailed or summary, it doesn't matter. And the attorney is going to present that to the judge, and they're going to see this. So that's part of the evidence that you have to supply to the court to show that the property was homestead. So if there are creditors out there, and again, can't be first mortgage, mechanics lien, or property taxes, but if there's other creditors out there, American Express, Mercy Hospital, whatever the case may be, they can't prevent the sale of the property from going through. And then the other thing that you need is the tax bill. So if you just scroll down here, property taxes. Oh, looks like the website is down. Let's try again. looks like it's down, but typically the tax bill is going to have this as well. It's going to show that the homeowner's been taking homestead on the property. So if you present those two things, plus the affidavit, you're going to get your homestead every time, and you're always going to be able to sell the property, without an issue. Another thing I want to show you guys is finding probate properties through the public record. So if you type in EST, and this is in date, if you put EST of and just put like Garcia or something, like a common name, or you can even just put like the first letter of the person's name, you'll find all the property that's owned by somebody that's passed away. So here we go, Jose A. Garcia. So if we click on this, we know that Jose Garcia, who is deceased, owns this property. So this is a good way to potentially get a listing, and you could send mailers and whatnot. And if we look here, it looks like it wasn't his homestead, because we don't see the homestead designations here. But that might not necessarily be true, because the homestead designation only applies when during the last year of life. So maybe Jose Garcia passed away in 2019 and he's been dead for a while, so obviously he's not taking homestead now. And there is a way to check that, but since I can't access the property taxes, I can't actually show you guys. But if you look at the tax bill, you could go as far back, I think you could go back like 6 or 7 years, and you'll be able to see when he was taking homestead on it. And that'll help you figure out whether or not it's exempt property or not. And we could try another one too. Let's try Gonzalez. Oh, nothing. Oh, because I spelled it wrong. So we put EST of Gonzalez, and it's going to show us, again, all decedent owned property with the last name Gonzalez. You go Antonio Gonzalez. See, so this person was taking homestead, and he may have passed away relatively recently. And if we look at the tax information here, he was taking homestead in 2020. So what may have happened is, like, the family members may have alerted the county that he passed away, and they're no longer taking homestead on here. But what matters is if they were taking homestead while they were alive. So this is a property that needs to go through probate in order to be sold. See if through the trim notice I can see something here. Nah. So this isn't the tax bill, but we could definitely see if somebody's been taking homestead on here. And you could theoretically use this. But you see how it says homestead, additional homestead? This is something you could potentially provide the court as well to show that the decedent was taking homestead out on the property. And again, this is a good way to potentially get probate listings as well. And this works in any county. You put either EST or estate of, and you'll be able to locate all estate owned property, and you could potentially get a listing. That's pretty much it for my presentation.
Thank you, Stephen. Stephen, I was going to ask you for 2 quick favors. First of all, I wanted to remind everybody this Zoom call is being recorded. So it would obviously be posted within the next week up on londonfoster.net. So if you'd like to review any information, it will be on our back office. Also, the PowerPoint presentation, Stephen will be sending it to me. with MA to have it uploaded also with the video. So you guys, for those of you that love taking notes, I appreciate you making all the effort, but absolutely this PowerPoint will be shared. Stephen, if you could please copy and paste your contact information, your auto signature. I think I had it before. Unfortunately, I'm driving right now, so I can't do that. And just so that everybody can email Stephen confirming that they attended the 2-hour continuing education. Before Stephen starts answering any questions, I want to let everybody know what the secret code. You have to email Stephen in order to get credit for it. It's going to be the joinlondonfoster.com website, www.joinlondonfoster.com. So Stephen, if I can ask you for a favor, after you type in your contact information in the chat, if you could just add that website, I'd really appreciate it. So guys, just remember, you have to send him, by Friday in the subject line, www.joinlondonfoster.com. And that way Stephen knows that you did attend and stayed so that he can make sure to register you to get credit for your continuing education. I'm sure Stephen is going to be getting a lot of questions, or you're probably looking them over right now. But in the meantime, I want to thank you, Stephen, for doing this. It's really, really interesting. Like I said, I had taken a class 5-6 years ago, but I did learn a lot. And I definitely have to brush up on my probate information, because there were certain things that I took note of that I really want to dig into, because I had no idea that that's the way that worked, especially in regards to the Ferpta. Does anybody have any questions? If you can just maybe ask Stephen now, anything that you would like to have addressed directly. Do you see any questions, Stephen?
Let's see. Regarding revocable trust, as you amend it every few years or so, is this done only by the attorney, or can it be done by yourself? So yeah, it needs to be done by an attorney. Never practice law by yourself.
Very good advice.
Yeah.
As realtors, I always go over this in the 101, but as realtors, guys, we have a couple of limitations. Number one, we're never to handle cash. Cash is not permitted, not just because of the fact of fraud and the fact that you can't trace it, but as actual licensed realtors, we are not authorized to ever handle cash. Even if it's your second cousin twice removed who gave you $100, you can lose your license for that. And the second thing is, we are never to write any copy on contracts or practice law. We can't, interpret law or contracts for clients. We can't translate it. We can't say, oh, but I speak French. I could roughly tell them this, because then you're practicing law. And when you do have those issues, obviously an attorney or the title company needs to be writing the copy. So absolutely great advice.
I have a question, Kate
Sure.
Smith here. First of all, let me say thank you for this amazing opportunity to hear everything I needed to know to refresh my knowledge, of course. I have a question regarding Ferpta. What was the name or the number of the document that you were talking about that allows the closing agent to hold the 15% in the event of a loss rather than a gain? So what would be the name and the number of this document that we need to prepare to allow the closing agent to withhold instead of the IRS?
So it's two things. So it's an 8288B.
Sorry. E2 can go. Can you drop it in chat?
82. Yeah, I can put it in the chat, but it's 8288B.
Oh, okay.
8288B. And it's also
Yeah.
reduced withholding certificate. These need to be
80 what?
82. It's in the chat. 8288B.
Yeah, we did file this form for one of my clients. Actually, I saw, and it's just that he's a French client of mine, and the IRS, unfortunately, the closing agent
It's not the brokerage. It's the owner. This is not his main property. I mean, this is an occasional property for him. People are like that. They have personalities.
Excuse me?
If they don't like the way we approach them or whatever, I mean, he
I'm
can say,
sorry,
you know
can
what,
I-
I
We
don't
gotta
wanna
mute
sell the
this
property
person.
anymore.
Somebody
Period.
else is
And then
talking.
there's nothing we can do. Not even if we do whatever, you know,
Let me see if
everything
I can find it
possible.
so I can
Okay,
mute
so
them.
basically this French client of
With
mine,
that
the
being
IRS
said,
took
what you saying here?
for 2 years.
Yeah, it takes a while. It's gonna take. It takes about 2 years. Um,
Okay. But if, see, the thing is that if we had all known that, is this something new? Or
it's been around
it
since
can,
1980.
okay, so apparently the closing agent was not up to par. Unfortunately, buyer's choice, not mine.
Gotcha.
But thank you so
If
much.
I can,
Now I
if I
know
can
to
interject,
contact.
if I can interject something real quick, yeah, absolutely. These things happen, especially because, if you don't hire the right title company and they're not on it. But one of the things, obviously we don't prepare this document. It's the title company that does. So one of the things that we could do is one of the things that we have to do is profile our seller and our buyer and know and ask the questions to the listing agent if it's the case, and find out if these people are foreigners, because if they are foreigners, it's going to come up. It's going to come up the day before, it's going to come up the week before. So if you I hate saying that, but like if you do your due diligence and realize that every time that you don't, it's that little hiccup. But yeah, no, it's kind of a nightmare, because when you find out last minute, oh my God, this person isn't an American citizen, then guess what? The title company is they have to verify that, and it's going to come up and it's going to delay and it's going to be a nightmare. And obviously the seller's going to be very upset because all of a sudden they have to retain their 15%. So one of the ways to avoid it is, I always say this in Spanish, hablando se entiende la gente, which means, talk it out. Talk to the listing agent and ask the question, oh, where's the seller from? Is he an American citizen? Is this going to be an issue? Does he understand that 15% of his proceeds are going to have to be withheld? And sometimes you have to think of all those little details. But absolutely, It does happen. It is unfortunate.
That was not at all the question, but anyway, thank you, Stephen. You're totally awesome. And next time I will reach out to you, because we had huge issue with the closing agent. No matter what we said, they were like totally not knowledgeable at all.
Yeah, look, most closing agents, I mean, you don't even have to be an attorney to be a title agent, right? But even the ones that
usually
are,
work
they're
with
not
attorneys. I
tax.
don't do with title companies.
Yeah, so I mean, but even if you're dealing with an attorney, they're usually a real estate attorney and they're not a tax attorney. But you need to speak to somebody like me that could actually like prepare these documents and make sure that you're putting money back into your client's pocket. But yeah,
Absolutely.
there are a series of forms that you have to fill out and send to the IRS in order to reduce the withholding.
Yeah, we did anyway. And I have another question for you regarding the tax on gift and gift or donation, etc. So it is 11,700,000 for this year, and with annual reporting up to 16,000. But the thing is that what I read and what I discussed with the tax guy, that you don't have to pay taxes on the 16,000 at all. It's just an annual reporting if you are, and then I was a little bit confused when I was listening to you. So which is it? Do they have to pay tax on anything which is in excess of 16,000? Because it was my understanding, the way it was explained, that it's only for, this is the annual accepted amount.
Okay, so
And subject to reporting only, not to taxation. That's what I understood.
so you have to report. So there's two things. There's estate tax and gift tax. So the number is the same regardless. And it was 11.7 last year. This year it's 12.06.
Oh, okay. Yeah, you're right. Yeah.
If you make a gift of over $16,000, you're supposed to report it. If you make that gift of over $16,000, you could do one of two things. You could either pay the tax on it, the 40%, or you use up your exemption amount, your $12,060,000. either way, you have to file a Form 709 with the IRS to report this gift. So whether or not you use your lifetime exemption amount, that's up to you.
Okay, exactly my understanding. Thank you so much for confirming. So I got it right then.
Yes.
Thank you. I'll be definitely in touch. You're my person of choice for sure.
Thank you. And also real quick, for the people that are sending me the emails, make sure you give me your license number as well. Otherwise I can't give you credit. So I need your full name and your license number, and then I can give you guys credit.
Thank you.
Thank you, Stephen. Anybody else have any other questions? Are there any other questions in the chat, Stephen?
Thank
you.
Absolutely, guys. We're here for you. As you know, we do these every other week. We do these trainings online. We try to make them interesting, try to make them lively. As you know, all of these trainings are recorded and provided for you in the London Foster back office, londonfoster.net, for your convenience. It always happens that you love the training and then you forget something about it and you go, oh my God, I want to go over that again. So we record them all. And Stephen, I believe, has already sent me the PowerPoint so that we can provide it for you. Guys, make sure that you write Stephen an email with your name, your license number, and the secret code on the subject so he knows where to direct it to. It's www.joinedlondonfoster.com. And that way he can, I'm going to be sending Stephen a spreadsheet with everyone who RSVP'd. So he'll be able to check off everybody who not only RSVP'd, but also attended, so that you can get your continuing education credit. Stephen, any other questions before we thank you again and sign off?
Nope, I don't see any in the chat. So
okay, wonderful. I'm getting texts, guys. I'm driving, so unfortunately I can't see them. I'll address them when I stop driving.
Excuse me, Stephen. I had a quick question. My name is Miriam. The question is, when you have a property under a corporation and one of the members dies, that there's no probate, or at what point is the corporation going to go to probate at any point in time?
So the corporation doesn't go through probate. That deceased shareholder's family has to probate that deceased shareholder's estate to transfer the shares. So if I own a property through a corporation and I own 50 shares, let's say, out of the 100, my family wants my shares, they have to go through probate to actually physically receive my shares of the corporation.
Okay, and if you're a foreigner, how does
thing.
that work?
Whether you're a foreigner or a resident or a citizen, if you own anything here in the U.S. that has a title to it, whether it's shares of stock, a bank account, a house, a car, a boat, anything with a title to it, or something that has a document that evidences ownership, you're going to have to go through probate.
Okay, but since you said that you can avoid that by putting it under a trust.
No. Well, yeah. So if you own the shares through a trust, you avoid probate. Yeah, trust is the only way to avoid probate.
So every individual every member of the corporation would have to have a trust.
Yeah, so the individuals would own their shares through a trust, and that's how you avoid probate.
Okay, gotcha.
Yeah.
Okay, so guys, oh my God, can you hear me, Stephen?
Yep, I can hear you.
Okay, beautiful. So guys, before we sign off, I want to remind everybody about a couple of things. For those of you that are planning on attending the London Foster 101, this is a Zoom call that we do for recruiting agents, and it's actually 4 times a week. We do it Monday, Friday, and Saturday at noon. We actually do one at night for those of you that are busy during the day. All you have to do is just go to Join London Foster, which is that secret code word. You go on there and you click on that middle button that says attend meeting. You can RSVP, pick the day you like. I also want to remind everybody that next Wednesday, we are going to be having our London Foster Pro training, but instead of being at 10 a.m., it is going to be at noon, as we are going to be doing a prefix menu at Brick in Dayland. The way you RSVP for that is you go to www.joinlondonfoster.com. You are going to click on live event. You can watch the video, see what the last one looked like. There is actually a link there for you to register as well. You can prepay the prefix menu. We have limited seating. I forgot what the number was. I think Bobby said we had 15 spaces left. So by all means, make sure you attend. Guys, it's a really great opportunity to, start hanging out with people. It's our very first event that we're doing, so it's going to be a lot of fun. We haven't done these live in a while for obvious reasons, but we're very excited to do them. And we're very excited that everybody has, just shown such a great reception to it, that we've gotten so many people to sign up so quickly. And if you've never been to a Tony Robbins event or a Tony Robbins motivational event, it's very active. It's very interactive, and it's a lot of fun. You get up and you scream and you clap and you stomp, and you get to really, talk about how to get yourself from point A to point Z. And it's very, very interesting. The last one that we did, I think, was 2 years ago. I don't know if Bobby's online, maybe he can correct me, but I think it was 2 years ago because of the pandemic. And it was full house, amazing, a blast. Dragon is very, very inspirational, and just a great opportunity for you guys to also share with us, whether you're a London Foster agent or not. And again, you go to joinlondonfoster.com under live event. And then I also want to remind everyone that Stephen has shared his contact information. All you need to do is send him an email with your full name, your license number, and the secret code, which is www.joinlondonfoster.com. Put that on the subject matter. You have to send this by Friday. What time Friday? Friday by end of day or Friday noon? You tell me, Stephen.
Friday noon is fine.
Friday noon. So that way you guys know, he's got to do a cutoff because he can't be doing this for the rest of his life. So let's go ahead and be proactive and, show him the courtesy to get that done as soon as possible. Other than that, guys, I want to thank everybody. I want to thank Bobby for sponsoring this. As you know, all these events are not just organized. We also have to advertise them. It costs us money and time and energy to get all of you on here. We had a great turnout. I'm very pleased. I think everybody had a great time. I'm getting a lot of messages privately and in the chat saying how great it was. So if anybody has any last questions before we sign off, or forever hold your peace, as I said, you have Stephen's contact information there, and you can always reach out to him directly.
Yeah, if you guys, I keep putting in the chat periodically. Like, if you guys have any questions, feel free to call me, send me an email. I've got no problem, talking with you guys one-on-one.
Okay, excellent. All right. So I'm gonna go ahead and sign off, and I thank you, Stephen, again on behalf of London Foster and Bobby and Miles and everyone in our team. A great training. Super excited to start building a relationship with you guys, and I thank you for your time.
Thank you so much for having me. Look forward to doing it again.
Okay, thank you, Stephen. Take care.
Bye.